Good morning, or good afternoon, good evening for all those that are connecting around the globe in these times of being online. Welcome to the panel titled Modern Law Enforcement in the Digital Ecosystem, Encryption, Lawful Data Access, and the Implication for Security and Privacy. We have heard a lot already this morning about the new plans when it comes to the EU, the existing EU security strategy, and then the next steps when it comes to cybersecurity aspects within it and evolving the current cybersecurity strategy and the NIST directive and so on. In this panel, we want to address, I would call it a junction between security and privacy, trying to have the humans or the human security in the center, whether it is protecting ourselves from the criminals or even from snooping and so on. So briefly, as the outline of the session, we have some distinguished guests today, but we'll first start with the introductory address by Edward Schileris, who is the head of EC3 at Europol. And afterwards, we'll move to a panel discussion. We have, besides Europol, policymaker from EU tech community, from ICE corporate sector, from Resecurity. So quite a mix of different perspectives. I'm sure it will be very interesting. Quickly, as it comes to rules of engagement, you have the opportunity to share any thought of any sort of thoughts through the chat. My colleagues will pass the questions to the floor, and certainly you can discuss also within the chat. It's always good to have another channel for discussion. I'll move straight to the opening of this panel, and I'm passing the screen to Edward for the introductory remark. Edward.
So good morning, everyone. It's a real pleasure for me to be here and address this opening speech and some keynotes from my side to you. And first of all, we are EC3, it's Europol Cybercrime Center, European Cybercrime Center, placed at Europol in The Hague. So maybe actually topic of our session is modern law enforcement in the digital ecosystem. So it means that it's not traditional law enforcement, it's law enforcement inside the digital. So in real life, we have lockers, we have vaults, we have some alarm systems, we have some protective measures against criminals usually. So actually it's the main purpose of using this kind of devices. We all the time when we leave our car, we turn on alarm, and usually it's encrypted. So what is encryption in general, how we understand it? I will not go very deep to these technical details and technical knowledge about it, but in reality it's one layer of protection. It's protection for privacy issues, for freedom of speech, for fundamental rights, for everything what we have in digital era. So actually it's a really old question, but it's necessary question for further discussions is do law enforcement need legal, lawful access to this data, and why law enforcement needs it. And last week, we just launched our main strategic document. It's called IOCTA, Internet Organized Crime Threat Assessment for 2020. And actually, in every chapter, it's some merges, some connection points to encryption. And more or less everything, I would say that more than 80% of traffic inside internet is encrypted, and it's good because in the beginning it was actually open internet, everyone can use it, everyone can read, and there were no privacy almost. So right now it's necessary, but from other side for law enforcement it's mandatory to have a possibility to protect our citizens, to protect our people from threats from internet as well. Because actually with new modern with new modern criminality, new threats are appearing as well. And especially in this COVID pandemic, what we have seen a lot of big increase of cyber activities online, because all the criminals moved from regular life, from streets to screen of computers. And of course, if it's easier to commit crime, if it's easier to steal money, steal property, steal identity, or to do harm, actually we need to be protected, and we need to have proper tools. We as law enforcement, we have actually our task from decision makers, from politicians, duty to protect actually, and only with proper tools, not only with declarations, we are able to succeed in this era. And my main message is that we need to write proper balance between encryption and lawful access to data from law enforcement perspective, of course with supervision of judicial authorities, with prosecutors involved, and of course with respect to human rights and privacy as well. Second message, maybe anonymity is not equal to privacy. We need to respect privacy, but I believe that especially in digital era, no one should be anonymous at all in general, because it leads to chaos, it leads to unorder, not to unorder. So I'm looking forward to take part in these discussions and to be part of it and to share our knowledge from Europol. And from my side, the last message may be that EC3 as European Cybercrime Center is the best platform here at Europol, here in Hague, to facilitate all these possibilities for law enforcement. And as we do here in Hague, everyone who left a bike somewhere, he used chain to adjust to log this bike, because it's some threats appears from regular criminals. So we use to use these locks in digital area as well, but for law enforcement, I think that we need to have exception. So thank you. It's my pleasure to be here.
Thank you, Edvardas, and I particularly like the analogies with the cars, chains, bicycles, because I think it helps us get, but even though analogies can be misleading very often, but it's important to have them to maybe explain the things a little bit better. And I think you actually have set sort of the agenda for the discussion. On one hand, you said that the encryption is all around, that it's very important that it protects us individually. But at the same time, the law enforcement authorities need to have some sort of a legal access. And the main question is how to actually balance the two, or have both. I don't know whether balance is a good way, or have both. And then you also mentioned something which is interesting. We'll get back to that later, I hope, which is the issue of anonymity. And it was touched upon in a previous panel as well, when it comes to some sort of e-identities and where the borders and the boundaries of that. But I'm sure the others will have their reflections on that. Let me move on to others on the panel, and I'll introduce them first and then pass the screen to each one of them. With us, we have Katrin Bauer-Bolst. She's head of unit cybercrime at DG Home at European Commission. Katrin, welcome. Robin Wilton, Director Internet Trust at the ISOC. And Selene Juponi, Managing Director at Resecurity. Welcome, Robin. Welcome, Selene. We'll start with the brief set of, again, reflections. You can reflect. You can also sort of set the scene from your angle, if you wish. And I'll start with Katrin, if you wish. Katrin, the screen is yours.
Thank you very much, and thanks very much for having me for this discussion. So I was asked to spend 5 minutes just on setting the scene for this while covering 2 points. So I'm going to speak 2.5 minutes on encryption and 2.5 minutes on cross-border access to electronic evidence, because of course, when it comes to access to evidence, encryption is not the only challenge we face. In fact, it is one of many, and I'll just pick out 2 for today's discussion. So on encryption, I think Edvardas has already eloquently described the challenge that we face. Encryption technology has become readily accessible for all of us, which is, of course, a huge benefit for international data transfers, for the privacy of our communications. And at the same time, the fact that criminals can also make use of readily available off-the-shelf solutions conceived for legitimate purposes makes the work of law enforcement and the judiciary plainly much more challenging as they seek to obtain lawful access to evidence. Edvardas already quoted some figures, and we also found in our workshops with experts that the use of encryption has negatively impacted the ability to gain lawful access to electronic evidence in between a quarter and a full 100% of their cases, depending on the crime area. Everybody saw that this trend is very much on the rise. I just want to add 3 points, perhaps, that we might want to come back to in the debate. First of all, it's not just law enforcement which cannot see what is happening, even sometimes with lawful access by way of judicial orders. But of course, it's the companies also. And that's a challenge that the Commission, which I work for, recently highlighted in its communication on a more effective fight against child sexual abuse. Here in the past, we had tools that were readily available that had been tested over decades with very high rates of reliability that could reliably detect the exchange of child sexual abuse materials that had already been previously detected and confirmed as such in communications channels to make sure that their platforms were not being abused for the exchange of this type of content. Now, that is no longer possible if you employ end-to-end encryption. And so my commissioner has tasked us to work with technical experts to map possible solutions to detect and report child sexual abuse in end-to-end encrypted electronic communications. Of course, in full respect of fundamental rights and without creating new vulnerabilities that criminals might in turn exploit. So I just want to highlight that also as one of the challenges that we face, that it also makes companies' own corporate social responsibility to protect children, in this case, from crime, much more challenging. The second challenge I want to raise here is that of being specific in the discussion. So what we see a lot is that there is this phenomenon of encryption without much differentiation. But really, if you look at encryption, there is no such thing as encryption. We have encryption at so many different levels, at the device level, at the app level, encryption on the transport layer or above. And each of those forms of encryption brings with it specific benefits and downsides when it comes to finding solutions to allow lawful access while safeguarding privacy. So I want to call for more specificity in the discussion, which I think is crucial. And then the third point I just want to flag is that we're dealing with an extremely diverse legal landscape. On the one side, we have a great difference between traditional telecommunications companies, which have always been subject to very strict requirements under national licensing laws. And then on the other side, you have the over-the-top service providers, such as WhatsApp or Signal or others, which are subject to an entirely different regime, but that is set to change in part at the end of this year, when parts of the Electronic Communications Code also become applicable to those services. So the very diverse legal landscape is another challenge that we face here. And the Commission, of course, has consistently called for lawful access to encrypted materials, that is, access granted for individual criminal proceedings and subject to the appropriate conditions and safeguards, while, of course, we have a firm commitment to encryption as a key tool to improve cybersecurity and protect privacy. And now allow me just 2 minutes to turn to cross-border access to electronic evidence to add to the rich palette of options for this discussion. We also see that the mere access to data across borders, even in an unencrypted form, has become a real challenge for investigators. About 70% of investigations into serious and organized crimes nowadays require access to electronic evidence. And in more than 80% of those cases, there is a cross-border link. For example, criminals are using a US-based email provider to exchange information on their crime. Or criminals are using that email provider to approach their victims. When it comes to accessing evidence in such a cross-border situation, when dealing with the United States, which is one of the most frequently requested countries, it takes more than 10 months through mutual legal assistance to get access to that evidence. And at that point in time, usually the rest of the trail has gone cold and the investigation has to be abandoned. So about 2 years ago, we proposed a set of EU-wide rules that would govern access to electronic evidence within the European Union for any service provider offering services here. and subject to strict conditions and safeguards, there could be an order for access to electronic evidence across borders within the European Union. And in parallel, we're also working with countries that are party to the Budapest Convention on Cybercrime on also updating the rules of that convention for cross-border access to electronic evidence, and negotiating with the United States on an agreement for similarly for cross-border access to electronic evidence, to make sure that we get our house in order, not just within the European Union, but also beyond with all of our partner countries. And I would posit that when it comes to access to evidence, this part of the picture is as important to deal with as the encryption problem, because beyond everything that we face in terms of technical access to the data, if we do not manage to solve the jurisdictional challenges, we will not get very far. And with those two big topics for the discussion, I'll close and thank you for your attention.
Thank you, Katrin. It will be, I guess we'll probably ask for an extension of the panel for some 3 hours of discussion to try to cover all these amazing and very important aspects. I'll just reflect on a couple of what you mentioned. One is that encryption is certainly not the only challenge that law enforcement has. So it's good to see the big picture of how important it is to strike different ways of penetrating the encryption or avoiding it in sort of the way to access the data, comparing with different risks and so on. And you mentioned a very important thing is that, and I think I can't agree more, that there are various levels of encryption. And you mentioned one type, which is end-to-end encryption, and there are different types of encryption. And that raises one of the questions is what, in case of end-to-end encryption, or some ways the encryption is implemented, what if the providers cannot give the access to data because they can't access, like what we had with the case of Apple? I'll leave it for the later discussion. And then the last, when it comes to the exchange of evidences, and it's good to hear that there is work also with the US and Budapest Convention. We are seeing some of the attempts by other parties to come up to some sort of a global treaty. We can reflect on that time permitting as well. This is just a sketch of various issues that were raised. I'm moving on now to Robin. I guess quite a different perspective now coming from technical community in a way. Robin.
Thank you very much. And yes, I think my role here is to, as you say, give something more of a technical perspective. And from that perspective, I have to say, I have yet to see a proposal for lawful access, for law enforcement access, that is genuinely selective. So I think we need to bear that in mind when we are judging whether what's important here is to say that we support encryption or to say that we support law enforcement access. So I would like to briefly cover 3 points. One is considerations arising out of systemic flaws in technical systems. The second is what I would call the problem of selective security. And the third one is the importance of making sure that this debate is genuinely open and informed and constructive. So as I sort of suggested, the problem with introducing systemic flaws into technical protections is that they are not selective. They put all citizens at risk, and they provide a target for all bad actors to seek out and to exploit. Billions of us rely on encryption every day to protect our confidentiality. As Edvardas very correctly said, it underpins rights to privacy, rights to freedom of speech, and so forth. And this is our protection in a digital world. Again, Edvardas very aptly mentioned things like bike locks. We wouldn't consider going out of our house and not locking the door these days, or at least not having doors. Encryption is our protection in a digital world. And just as we wouldn't contemplate not having locks on our doors, so we shouldn't contemplate going online, living our lives online without proper protection. And so I guess one slightly cheeky question I would ask Edvardas is, does his bike lock have a backdoor? Does it have a law enforcement option? The pandemic has driven more of our everyday life online, which means that flawed encryption systems put more people at risk of fraud, at risk of identity theft, and even in physical danger. And there I think of Bruce Schneier's point that the advent of the Internet of Things means that digital devices have physical effect now. Autonomous vehicles, smart locks for homes, those are digital devices, but if the wrong people can get access to them, the physical effects can be devastating for the individual concerned. And fundamentally, you can't have access to encrypted data without weakening encryption. Encryption as a system is a data confidentiality mechanism. If you redesign it so that it no longer delivers confidentiality, it's not really encryption. So the point of technical protection is that it removes human error and judgment from the system. Edvardas doesn't have to worry about whether he locked his bike to 50% security or 60% security. When the lock is closed, it works. The human element, the human fallibility, has been taken out of the system. So fundamentally, the technical problem here is that you can't design encryption that keeps Alice and Bob's messages confidential, but only until Charles wants access to them. The cryptographers have said that all along. And to my knowledge, no government has been able to suggest a viable solution that overcomes that problem. And I think it's naive for us to assume that governments don't have access to people who could design it if it were possible. The second point I wanted to raise was one of what I call selective security. And I'd like to start that bit with a quote from the Australian Prime Minister, Scott Morrison, from June 2020. He said, "Governments and institutions are being targeted by sophisticated and widespread cyber attacks, covering all levels of government, as well as essential service providers and businesses." So we should be aware that governments' attack on end-to-end encryption would result in mass quantities of personal data, transactions, and so forth being accessible in clear at the sites of service providers and other intermediaries. And that creates huge single points of failure, and it creates a massive target for criminals and state cyber attacks alike. And so I think there's a legitimate question here about why any country would lower the level of protection available to its own citizens within its jurisdiction when it is at the same time aware of the threats from outside. Lastly, turning to the topic of making sure that this debate is open, informed, and constructive, I again want to start with a reference to one of the so-called Five Eyes countries, where there was a suggestion that industry in this domain has not been transparent enough in designing and developing encryption technology. I won't name the individual or the country concerned, but that's a quote from May 2020. And I reject that suggestion. I think one need only look at the standardization processes for encryption algorithms, for example, through the NIST competitions, the development process for encryption and digital signatures, the operating procedures for public key infrastructures and certificate authorities, the development of secure communications protocols through open standards bodies such as the IETF. I think one only need to look at those efforts to see that transparency is fundamental to the industry, and the security industry understands that because one of its mantras is that security through obscurity is not security at all. So I think we need to bear that in mind when we're conducting this debate. And it has two sides. Is industry being open and transparent enough? And are those calling for access to encrypted data presenting a balanced picture? And I think one can legitimately say that the comparative value of other methods of access, such as open source intelligence, communications metadata, other digital data such as location and proximity, which we're coming to grips with in COVID, data mining and inferences from bulk data sets, all have a role to play in ensuring effective law enforcement access to data. So I think a focus on introducing systemic flaws into encryption technology is not balanced, it's not helpful, and ultimately it leads to a transparency shortfall, which doesn't actually advance the debate. So I think legitimate users of encryption deserve to be given full weight as stakeholders in the discussion, and I'm delighted to be here, and I hope I will represent them adequately.
Thank you, Robin. Sort of a different perspective, which is very useful, and I'll underline a couple of your thoughts that I think are very relevant, particularly. One is that, and I think you mentioned it clearly, we support law enforcement access, and we also support encryption. So how can we support both? That's probably one of the questions we can reflect afterwards. And I think one of the responses is what Katerina already said, is that we have to look in greater details of both what law enforcement needs and what encryptions we have and what sort of systems we have and so on. Second one that you mentioned is the effect. The effect of a breach into personal privacy by criminals because of weakening encryption can lead to physical danger, and we are seeing more and more, unfortunately, this merger of the virtual world and the digital world. I'll move on to Celine with a final sort of a comment address, and then we'll get back to some of the questions. In the meantime, I encourage everyone to post comments in the chat or questions, and let's steer up a little bit the remaining time. Celine.
Thank you so much, and thank you for the invitation to this interesting panel. I would like to start with a presentation that for me, we are working a lot with law enforcement. I'm also in the Women for Cyber. I'm one of the founder of VIXO, and I am into the Europol part of digital forensics. So there is a big discussion, of course, during the new technology, backdoor, but also the privacy discussion. Of course, what we have, of course, we have to acquire data. Data acquisition for defense, offense, or intelligence. We are seeing in this period, into the last year, a lot of attacks, of course, but a lot of also of criminals that they have a skill very high. First of all, I would like to do an example. Every new technology, unfortunately, bring us also other form of crimes, new crimes. We saw on the past example in the past months also that some researcher help some law enforcement agency to get access to a specific group of child pornography data. But we are also seeing that when we found something, the criminal are a step away from us. What we need to do, of course, we have some problem also of information sharing, also for different legislation, national regulation, and we have, this is, for example, what we apply some technology. This is a real case technology to fight terrorism, because also with my company, we profile threat actor, we fight cyber criminal, but also we support law enforcement for cyber terrorism. And of course, first of all, we put the reverse engineering. So into our technology, we are seeing that, for example, this small part to apply the reverse engineering, identification of high-risk individuals with the cyber intelligence, with the target development, with also operation monitoring. So we apply some stuff to gain the goal and to have the goal. First of all, we identify a lot of problem into different I call the heathen country. It's not like a financial heathen, but it's also the cybercrime heathen. And for the national regulation that I mentioned before, we starting from responsibility, of course, accountability, but also the investment. Because when we are doing some investigation, we also see that there are a lot of law enforcement that they have investment to fight cyber criminal, and the other no, but we support also. And then the intelligence cycle. All these four topics can help us to fight cyber criminal in general. We apply not just for the encryption and the technology, but we apply the human part also to investigate into the forum of dark web. We know that the dark web nowadays is the most powerful and plenty of dark stuff. So all the criminology, also the mafia that we have, for example, in Italy, they use at this stage the dark web. And first of all, before to get access or to try to reverse engineer some tools, some products, some technology, we starting with the part of the human, with the threat actor, and into, with our analysts, for example, into some forums of dark web. And first of all, there is a correlation, of course, because also the criminal, we discover that they are victim, for example, of data breach, and this helps us a lot to find them for geolocation, with the support of law enforcement, and then to give them to have the right place to bring them. We have a lot of marketplace, and we know also that there is a big issue, for example, also for creating backdoor, for vulnerabilities. When we are speaking about, for example, 0 days, we found a lot of criminals that they are using zero-day exploit also to attack critical infrastructure and so on. But also we are seeing a lot of companies that are involved into lawful interception or in fight cyber criminal that are buying 0 day to or try to reverse with their engineer the technology to gain access to the criminal. We have a lot. This is just some screenshot of what we found on the dark web. What we have to control also, we have to apply, I think, at this stage, of course, a cooperation, national cooperation and international cooperation. Because we saw also from the past investigation that we found a lot of data from the cyber intelligence, from operation, from ground operation, from lawful interception, but also with cyber operation. So at this stage, we went a lot also to some conference of lawful interception and so on. We saw there is some closing environment, and I think when we have to fight and to gain the same goal, we have to collaborate. So we have to collaborate. What we are going today, of course, there are regulatory and compliance, the security engineer, big data, orchestration, machine learning, artificial intelligence, but also from all this kind of technology, all this kind of data, we need to gain the right data, of course. And when we saw in one case, for example, we saw there was also manipulation of data, and the technology and the backdoor was not working in the best way. So there is also another aspect when a backdoor is going to work well, or when a backdoor is going to be manipulated also from the criminal. So this is another aspect that we have to consider. I think today, and also in this panel, there are a lot of interesting points to start, because we are in the new world. We are in the cyber is the modern world, of course, and but a lot of citizen doesn't understand, for example, what are the risk and so on. So also about from perspective, from data and so on, but they would like to use encryption messages, and also, for example, encrypted phone. And when we get access, for example, to the encrypted phone, there are, of course, a lot of interesting data for the criminal. What is my advice? What we need to do to do better this kind of relationship between backdoor and privacy. In Italy, also, last year we had a big scandal because there was a Trojan that spied also other kind of citizen, and they didn't manage the company. So first of all, it's to the best way is, okay, testing this product, also to insert to the criminal and so on, Trojan, remote access, because when we found some problem, there is a big scandal, of course, but also other citizen can be spy, and it's not correct. From my perspective, I think major collaboration also with the law enforcement, but also when we found something, as I told you before, about some information and some companies that build this kind of infrastructure, is good to testify before from multiple companies and also multiple law enforcement. Thank you for your attention.
Thank you, Selen. It was quite interesting to hear the practical examples of how you can actually get to some interesting, important data without breaking the encryption. You basically mentioned some of, like, human intelligence, reverse engineering, and so on. Mentioning AI and other tools that are emerging. So we definitely have a lot of work to do to explore other ways. You also mentioned the importance of security of the products that we are insisting. I'll get back to that in a minute. And then the cooperation. And I think that's definitely the key word. We all agree, I'm sure, on that. Trying to explore maybe other innovative ways that can emerge from the industry and be used for the law enforcement work. Now, we don't have much time, and I purposely sort of allowed you to go all a little bit beyond what we expected, because I think it was useful. There are four, not different, but very diverse perspectives. And I want to get back to the question, which is sort of a quite big one, but get back to what Robin said. Can we have both legal access to data and encryption? Can we have both? And then the question is, sub-questions would be, what sort of data law enforcement agencies need, when, how, so that that wouldn't endanger encryption? Could that be acquired without weakening encryption? Edvardas, in some of our previous preparations, in a way, you mentioned encryption is a right, but it's also a privilege. It's a responsibility. Katrin, you mentioned with all the access to data, we need to respect rights without creating vulnerabilities. So these are all the underlying bits. So what other tools can we use? I'll maybe start with Edvardas first. Can we have both?
I believe yes. Actually, main thing is first to agree on it. If we agree that law enforcement needs to have this kind of access, then of course we need to go to technical implementation. I don't believe that it's necessary in these discussions to go so deep coding experience and to go deep to the encryption algorithm. But in reality, right now we are running around and around and around. It means that first we are raising discussion about privacy, then that no one can access it, and then that in some special cases as child pornography and dark web, etc., maybe it could be better that someone would have this right. So as I said, we need to agree on common principles. If we agree, everyone agrees that it's a duty of law enforcement to fulfill law enforcement duties properly, and citizens should be safe and should have address where to go if something happens, then of course we need to go to technical implementation. Because right now I would say we are in the first stage, and everyone delivers his point of view from his angle, and I don't believe in miracles, that it's philosophical debate. It's we will weaken encryption, we will do stronger it, or there will be no encryption at all, and what it is in the reality. Encryption is becoming better and better every day, and it's sure. And when you compare what we had, for example, 5 or 10 years ago.
We lost your microphone, Edvardas. Maybe you're muted, or just check the mic.
Sorry?
Should be okay now. Yes.
Maybe everyone believed 10 years ago that it was perfect one, but right now we can say that it was not. And I believe that in the next 5 years it will become even better and better. But actually we need to start from some point of view and to agree. When we agree, I think that we can solve both issues: privacy, not weakening encryption, but to fulfill our obligations properly.
Thanks. I wanted to, before passing to Katrin, I wanted to briefly hear also from Robin on the, basically a reflection on what Celine mentioned or listed, the other ways, the other technical, sort of technical or techniques to get to some sort of data. Would this sort of cooperation between technical and private sector in finding other ways to access data be something that can help the law enforcement? And could we maybe start with, and Edvardas mentioned child protection, and I think Katrina as well, child protection, that's something we all agree about, particularly in Europe, but around the world. Could we start a very practical cooperation, let's say ISOC, REST security and EC3, on child protection, how to find a mechanism which doesn't endanger encryption, but actually helps getting the data about the perpetrators? Robin, any reflections?
I think that's a discussion that we can't avoid having. We must have that discussion, and we must have the stakeholders around the table. In particular, we are very conscious that as an advocacy organization, based on our technical understanding and our understanding of the implications of the technology, there are domains in which we are absolutely not the expert, such as child abuse, domestic violence, and so on. So it's absolutely critical to have the experts in those domains with us at the table, yes. I think I would sound a note of caution about basing our approach on a use case such as child abuse. And again, I will refer to a quotation, if I may. Encryption is an overwhelmingly good thing, and it keeps us all safe and secure. Building in backdoors is a threat to everyone, and it's not a good idea to weaken security for everybody so as to tackle a minority. Now, I'm not minimizing in any way the danger or the repugnant aspects of child abuse, but that quotation was from Robert Hannigan, the former director of the UK's Government Communications headquarters, GCHQ. And I think we need to take that kind of opinion from someone in that position very seriously. So I do think it's important to have those stakeholders around the table. I absolutely agree with saying that there are other options. And as I said in my opening remarks, I think there is still something of a transparency shortfall where those other options are concerned. I'll give one illustration of that and then stop. My former colleague Susan Landau in the States spoke to a law enforcement, basically a police chief, and she said, "Is encryption the main obstacle to your law enforcement activities?" And he said, "Well, let me tell you, we've got a crate full of telephone handsets, and we can't get the information off them." And she said, "Well, is that because they're encrypted?" And he said, No, it's because my officers don't have the skills to get information off phone handsets. They're not locked, they're not encrypted. We just don't technically know how to do it. So I think there's an element here of asking for the top brick of the chimney, as my grandmother used to say, when there are actually many steps that we could take before we get to that extreme.
Thanks, Robin. I see Catherine is taking notes, so I guess you have quite some reflections. And I'm back to your sort of a point that we need also better international cooperation when it comes to exchange of e-evidences, and to what extent some other aspects like that, plus the combination of cooperation with private sector, which might have innovative solutions, can actually be more important than sort of chasing, I wouldn't say against encryption, but having encryption as one of the key issues in discussion. Catherine.
Yes, thank you. And I do recognize that if we tackle e-evidence as well, we're going to be completely we're going to be needing the 4 hours that you mentioned earlier. So let me focus on the topic that everybody is most excited about, which I completely agree. And I just want to add some reflection to Robin's, which I find very pertinent. I think fundamentally it comes down not just to having the stakeholders around the table, but also recognizing that there's fundamental rights at play on both sides. And even though we might be dealing with a minority here, hopefully, of course, crime will always be a minority of use of any legal system. At the same time, the obligations of governments also go towards the protection of that minority. And indeed, it can only ever be one measure in a full toolkit, and upskilling law enforcement is an absolutely key aspect in this respect. And I take note that Susan Landau actually collaborated on a very, very good project that I believe was run by the Carnegie Foundation on coming to a set of principles to govern the discussion on encryption, which she also recognized cannot always reign supreme. And I think that brings me to the main point here, that there is a tendency in this debate to basically call for a binary approach, that there's either encryption or there's no encryption, and any solution that seeks to combine the benefits of encryption with the possibility for lawful access is not possible, and therefore we should give up looking for it. However, I note that, for example, the financial sector has long benefited from very strong encryption for its financial transactions of enormous sums around the world, while at the same time complying with money laundering obligations, because it does need to ensure that there's monitoring of transactions for money laundering. So I would say that the binary situation is not as extreme as it's often made out to be. And just coming back to the very pertinent examples that were used at the beginning of the house door lock or the bike lock. We've always recognized that everybody has a right to lock their doors, and that everybody should be in a position to choose whatever lock they choose. However, if there is a judicial order for a house search, then police are allowed to access that house. And that's exactly the type of situation that we need to create here, that we allow everyone to lock their doors and that everybody can benefit from the security of a door lock or of a bike lock. But when there is a case where the police recognizes that there is a need to act and the judge confirms this need, that there is a possibility to obtain access. And that really comes down to the fundamental point. I come back to the fundamental rights here. There is a conviction of governments that has been expressed also in various EU positions that our rules, including the criminal laws, have to apply online as they do offline. And if we do not find a solution to this, then in a very important sector, we're basically creating a complete blind spot. And I'm aware of a lot of work that has gone on in terms of looking at behavioral indicators, metadata, all sorts of other data, which I would posit is often more privacy invasive than getting access to the individual pieces of content that might show that there's child sexual abuse being exchanged in my case point, but could also be drugs or explosives or whatever else you may have in terms of illegal activity. First of all, getting there on the basis of other sets of data is not necessarily less privacy invasive. And secondly, it is not as effective. I keep coming back to child sexual abuse because it's an area where we have very specific tools to identify known content that have proven reliable over decades of use and have false positive rates in under 1 in a billion. And when you look at the reports that are generated on the basis of these tools, which can only work if you look at the content and analyze it, as compared to reports that are being made on metadata, there is no comparison. It just isn't anywhere close to as effective. And that's why I think we cannot shy away from having the difficult debate about how we can ensure security and privacy while at the same time allowing for lawful access.
Thanks, Katrina, particularly for this last bit, helping us understand to what extent metadata and other approaches, or at least that have been used, are effective. And as Edvada started with analogies, I think you touched upon the lock and the judicial order to search the house, and certainly the rules that apply offline also apply online. We've seen it around the world, more or less agreed. The question is how. And that's where the analogies sort of end, the comparison between the lock and the encryption, which are definitely different. I want to pass to Celine with a very related question. You touched upon that, and we are talking about the ways to, I wouldn't say go around encryption, but find the ways to access the data. You mentioned security of digital products, the vulnerabilities. And basically, I want to give a broader context, or connect our discussion, maybe even with the discussion which is following after the lunch in this very forum, which is about security by design, or securing the products. Basically, we have the EU discussing the way to secure new products and services. We have the UN group of governmental experts within one of the reports mentioning the ways to reduce vulnerabilities. We have even the global initiative on data security by China some weeks ago, talking about not inserting backdoors. I'm involved in Geneva Dialogue on Responsible Behavior, where the private sector again talks about security by design, and so we want to sort of force the companies to make more resilient products without vulnerabilities. At the other hand, we sort of want them to find a way for, whether it's a vulnerability or not, but be able for law enforcement to get into data. Is it conflicting, Celine?
Yeah, there is a conflict, of course, because first of all, you mentioned the security by design, and of course also the GDPR mentioned the security by design, privacy by design. But we know at the moment that a lot of the major part of the company doesn't apply the security by design, also because they have to deliver quickly their product and so on. Because when I did some forensics, I mentioned, for example, the IoT. But also from insulin pump, that it's a healthy part, that it's very important. From this perspective, we need security by design because there is a life of a person that is involved. And I didn't see any security by design when I did the forensics on these insulin pumps, unfortunately. But you mentioned, okay, the security by design and the vulnerability. What is the, I think, okay, of course, for security by design, we have to apply the secure development life cycle. But I saw when we test or we are doing some forensics or gathering information from some technology, that a lot of this, they don't have a lot of vulnerability. So at this stage, I think, first of all, the company that also provide technology has to design a security life cycle. If they have on the paper, of course, all one of them have. But when we are going to find information, and the forensics is not in the same way. And this is important also for criminal perspective, because if some criminals can use this issue, this exploit, this vulnerability to get access to some infrastructure, so we need to have security by design. But then we know that there are also a lot of researchers that they are find vulnerability and so on. For example, in Europe, there is the responsible disclosure. In Italy, just we starting from 1 year with the responsible disclosure, also for find the vulnerability into the product. This is a big discussion because, okay, in which way, if there is a product that is a secure product with some lawyer and some level, how who is doing investigation as law enforcement, also consultant for law enforcement, get the access? This is the big question that you mentioned. And I think, of course, I think when a product is designed by a human, is a human that could do some mistakes. And the vulnerability, unfortunately, we found. Unfortunately for security and privacy, but fortunately also from investigation perspective.
And that's basically what also
Yeah.
Robin mentioned when it comes to the problems with if we sort of try to weaken encryption. I'm sure there are.
I would like to add also that Catherine before mentioned the money laundering, of course, and I think our next goal could be also into the crypto forensics, into the crypto investigation, because when we found some money and we need to follow the money, of course, some investigation in Bitcoin or in blockchain or other crypto, it's not so easily. If I think someone has to design other crypto, I think it could be useful for law enforcement get access to some raw data.
Thanks, Lee. I'm sure all of you have some reflections. I do have some more questions, but I'm sure you want to reflect on this. Any one of you, just raise a hand or just start if you wish. Or should I throw the next one? Yeah, Catherine.
Yes, I just have one more comment because I think this point on the transparency is really important, and something that that I keep wondering about is whether our current approach of basically saying where law enforcement is capable of doing lawful hacking, either themselves or by using companies, access can be granted, but a systematic approach based on rules that we all agree between ourselves, including transparency and accountability, is somehow not possible in the same way. And I think that really begs the question as to whether from a safety and security perspective and the privacy of the user perspective, we're better off with this sort of who's successful is lucky or who's lucky is successful approach is much better than trying to come up with solutions that work with a different level of oversight and are less sort of beholden to chance when it comes to who gets to the zero-day exploit first. And I'm just throwing that out there as a little grenade for further discussion. And I see we now have some questions in the chat as well, so I'll leave it at that.
Yeah, it is basically reflecting on, and certainly I'll pass the floor to the others as well, others, Robin, if you wish. Quick comment from the participants. So Simon Thornton, Director of Cyber Threat Analysis and Response, Diverse IT, says, in the financial world, the anti-money laundering monitoring is carried out in the processing environment before it is encrypted on the link. Therefore, no keys are needed. If you look at how many intrusions occur, the attackers steal or replace the crypto keys. if access to the key is the hinge for access, why weaken crypto? I guess that's sort of a reaction also to Celine, but I think it's quite an interesting insight into money laundering processes, basically. And maybe, Robin, I see you've raised a hand, and a sub question for you is also, is that one way that we access data before they're encrypted, or that's even more troubling, Robin?
Yeah, right. I think the anti-money laundering example is not necessarily helpful because the banks are legitimate and indeed generally a required intermediary in that case. So they have to know what's going through their systems. I think the other point here is that when we start to talk about duly served warrants, and this is language we've heard from the States as well, that it should not be possible to put data beyond the reach of a duly served warrant. I think we need to look very carefully at the implications of that, because actually what that does is it imposes obligations on the manufacturers of digital solutions that are not imposed on manufacturers of security products in the real world. We're actually going further than what is required in the physical world. For instance, if I buy a safe to keep my documents or other things secure at home, there is no obligation on the manufacturer to somehow weaken part of the casing just in case law enforcement want access later on. There's no enforcement on the manufacturer, obligation on the manufacturer of door locks to ensure that there's law enforcement access other than a brute force attack, i.e. breaking the door down. So I think we have to be very careful of analogies that lead us to go further in the case of digital data than we would think acceptable in the real world.
Thanks, Robin. Eduardo, any reflections?
Yeah, actually, I think that we are in the early stages of all regulation, because if you look to regular vault, not digital vault, you will find tons of different rules, regulations, how to manage your private business, how to produce these lockers, and etc. And in a digital environment, we almost don't have anything. And actually, big players are private companies who wants to earn money, and that's all, and they don't care about anything else. And actually, this analogy that we don't want to weaken anything, actually, if society agrees that there is certain digital vault, and one day you can realize that your bank account is zero and law enforcement cannot do anything, and it satisfies everyone, all the parties, so then it's okay. But I believe that when I see some, for example, 1 month ago, maybe, it was first casualty when, because of ransomware attack on hospital in Germany, one lady died because it was not possible to deliver services for her. And I believe that unfortunately, when we will see more and more this kind of events, we will be much more negotiable between each other, because right now, actually, I still remember maybe 13 years ago when one telecom provider who also provided internet, voice over internet services, they said that if you will have call, when someone calls from internet to landline, we will ensure interception from our side if you deliver order from court. Otherwise, if it phone to phone, it means that internet to internet, it's not obligation from our side because we are not telecom provider as well. So it means that there are many tricky games in this area, but as understood, as I said before, we need to agree on principles at first. And if it's obligation for law enforcement, and actually state as one entity wants to protect their citizens, actually we need to agree on some rules. Otherwise, it will lead to chaos and actually to blames from one side to another, but it will not reach any results and conclusions in this case.
Thanks, Eduardo. You basically resonated what also Robin mentioned, this reapproachment of the digital and cyber cyber and real world when it comes to effects, and this will definitely be a game changer. Hopefully, it will speed up the discussion on how to. We're running out of time. I do have one last question for you. So I'll ask it, and then I'll read or summarize my own messages and leave you to think how you would respond, because I haven't prepared you for that. I need a tweet from all of you on what could you or your institution do next in this discussion to basically come up to the way how to have both of that. That means either you personally or your institution, probably your institution more than that. I'll start with Celine, but before that, I'll leave you to think, and I'll just try to sum up my key takeaways. First of all, I think we all agree that we need to have both legal access to data and encryption. I haven't heard any sort of against any of those. Then we have to look more into details of encryption and more into details of what law enforcement actually needs out of data and how to get that what is needed without weakening the encryption. And I think we generally agreed also that weakening the encryption is not the good way. Then working with industry or the law enforcement policymakers and industry, not only searching for innovative approaches that can help collecting data, which might go beyond encryption, but also starting maybe a more practical cooperation, why not, with the topics such as child protection and trying to see how to go over the challenges that appeared in child protection because of the encryption. And with that, I'm passing the floor to you with a tweet. So Celine, what can or will you do next?
So it's a big challenge, of course, and I think it was about, and we have to think also for the future, and in fact, we are doing with EXO, the European Cybersecurity Organization, a small group of IT and tech guy, how we can help and how is going to cybersecurity. So, as I told you, for my perspective, at the moment, we need to have a table to discussing for this from a European perspective, from Europol perspective, from, of course, cooperation with public and private. But from my side, at the moment, as I told you, first, we found vulnerability. So from investigation perspective, we can use that vulnerability, of course, to monitor. From other side, from security and privacy, so it's a big discussion and a big deal. So for the moment, we are going to start to speak about this, and I think in the next future, some country decide from himself, but also we have to think from a Europe part how to solve this kind of challenge.
Thank you, Celine. I did allow you to do a blog instead of a tweet because you gave some more time to the others to think. A tweet to Edvardas.
So tweet is really make Europe safe. It's our motto actually for Europe also. We will continue our efforts with and joint efforts with Catherine with new possibilities of new law and new research and development areas with industry as well. So it means that we try to combine two areas: needs of law enforcement, not weaken encryption, and to gain lawful access for law enforcement. So mainly, it's really real short is this way.
Thank you, Edvardas. Robin.
I think the Internet Society will continue to do what it has always done, to convene multiple stakeholders, to contribute its informed advice on the technical options, and to explain the full practical implications of undermining confidentiality and security online.
Thank you, Robin. Catherine, the zoom out perspective.
Yeah, so there's two concrete things that the EU is doing. So first of all, there is a discussion going on right now among the member states in the context of the Council on the role of encryption and the challenges it can pose for criminal investigations. And secondly, our commissioner has tasked her service, so us, with finding solutions to ensuring that child sexual abuse content can still be detected in end-to-end encrypted environments. That is a tall order, as I think this debate has made patently obvious, but that is what we will be working on.
Perfect, thanks a lot, and that could be really the good step for cooperation. Well, Celine, Catherine, Robin, Edvardas, many thanks for joining us. Thanks to all of you for joining us today. We have the lunch break for 1 hour, then we return to session 3, Securing International Supply Chain, Cooperation, Trust and Trade, at 13:45. We will probably sort of build up a little bit on this discussion as well. Thank you again for joining, and let's make sure that we stay in touch. Bye-bye.
Thank you.
Thank you all.
Thanks, everyone.
Thank you.